Welcome to today's episode of Legally Wavering here. We're going to read Implementing the Due Process Standards, Statutes, and Rules Governing Service and Process. Section 3. As the first part of this chapter states, service on the defendant must be both constitutionally sufficient and authorized by a statute or rule of the court system in which the case is filed. When you enter law practice and are first asked to serve process on the defendant, you won't engage in original constitutional speculation about what might be a proper method to do so. You will turn to the rules of procedure or state statutes governing service of process in the court in which you're filing a suit. Those statutes have been around for a long time, were drafted with constitutional constraints in mind, and have probably withstood constitutional challenges or been amended to assure that they will. In addition, service must be made in a manner authorized by applicable rules of statutes. You cannot just use any method you like as long as it meets due process standards. You cannot just use any method you like as long as it meets due process standards. Every state has either court rules or state statutes setting forth the permissible methods of service of process in the courts of that state. For actions brought in federal court, the proper procedure for service of process are set forth in Rule 4 of the Federal Rules of Civil Procedure. We will explore the federal methods as a model. Many state procedures are quite similar. First, we cover some basic points. Some practicalities of service: who, what, and when. Who gets involved on the defendant? Who gets served on the defendant? Under Federal Rules 4C1, the complaint and the summons must be served together on the defendant. The complaint is a plaintiff's initial pleading, setting forth her claims against the defendant. The summons is an official order of the court commanding the defendant to appear and defend the action or suffer default. The contents of a proper summons are prescribed in detail in Rule 4A. Thus, the complaint arises. The complaint apprises the defendant of the claims against her, and the summons orders her to answer those claims. Who serves process on the defendant? One might reasonably expect that the court would take charge of notifying the defendant that she has been sued. Generally, however, the duty to serve process is delegated to the plaintiff. Federal Rule 4C1 provides that the plaintiff is responsible for having the summons and complaint served by the defendant. The plaintiff does not have to serve it herself. However, Rule 4C2 provides that any person who is at least 18 years old and not a party may serve a summons and complaint. The plaintiff's lawyer could do it herself, or more likely she will hire a private process server to do so, or a sheriff or deputy sheriff authorized to serve process. If service by mail is authorized, however, counsel probably will do so. When must service be made? The complaint and summons must be served after the complaint is filed. See Federal Rules of Civil Procedure 4B. Summons issued after filing the complaint. Rule 4M provides that the court must dismiss an action if service is not made on the defendant within 90 days after filing, or order service to be made within a specified time. If the plaintiff shows good cause for the failure to make service, the court must grant an extension of the time to make service for an appropriate period. If no good cause is shown, Rule 4M still authorizes the court to extend the time of service, but it has the discretion to dismiss instead. Dismissal for failure to make timely service would not bar the plaintiff from filing a new action, but the plaintiff would have to pay a new filing fee and would risk statute of limitation problems in refiling. The complaint summons must be served after the complaint is filed. See Federal Rules of Civil Procedure 4B. Summons issued after filing the complaint. Rule 4M provides the court must dismiss an action if service is not made on the defendant within 90 days of filing, or order service to be made within a specified time. If the plaintiff shows good cause for the failure to make service, the court must grant an extension of the time to make service for an appropriate period. If no good cause is shown, Rule 4M still authorizes the court to extend the time of service, but it has the discretion to dismiss instead. Dismissal for failure to make timely service would not bar the plaintiff from filing a new action, but the plaintiff will have to pay a new filing fee and would risk statute of limitation problems in refiling. Serving natural persons under federal laws. Rule 4E provides four methods to serve the summons and complaint on an individual defendant person. The process server by deliver the purpose to the personally in her service whenever she can find the defendant. Federal Civil Procedure 4E2A. Leave the summons or complaint at the defendant's dwelling or use your place of abode with someone else with agent discretion who resides there. Federal Rule of Civil Procedure 4E2B. Deliver the summons and complaint to an agent of the defendant authorized by appointment or by law to receive service of process. Federal Rule of Civil Procedure 4E2C. Follow the rules for service of process of the state where the federal court sits or the state in which service of process is made. Federal Rules of Civil Procedure 4E1. The last provision gives the plaintiff several alternatives to the three methods specified in Rule 4E2. Suppose that Arnett sues Costa in federal court in Kentucky. Costa resides in Arkansas but is subject to jurisdiction in the Kentucky action because the case arises out of the accident that took place in Kentucky. Federal Rule 4E1 allows Arnett to serve Costa under the rules of service of process that apply in the Kentucky courts, or if she is serving Costa in Arkansas, to use the Arkansas rules of service of process. Serving corporations and other entities under federal Rule 4. Rule 4H prescribes methods of serving a corporation, partnership, or association. The term association covers a wide variety of groups that may be sued under a common name, including labor unions, church groups, political groups, and other unincorporated entities. Service can still be made. Delivering a copy of a summons and a complaint to an officer, a managing agent, or general agent of the entity. Delivering the papers to an agent authorized by law or by appointment to receive service of process. Federal Rule of Civil Procedure 4H1B. This does not refer to a general business agent, but one specifically empowered to receive service. For example, many states have statutes authorizing service of process on the state secretary of state for actions against corporations doing business within the state. For example, see Florida statute, section 48, 1.1, 2010, or Georgia Code, section 9, 11, 4, 2010. Serving process under state rules for serving corporations is either the state where the federal court sits or in the state where service is made. Federal Rules of Civil Procedure 4H1A. The last provision is a little confusing. Federal Rules of Civil Procedure 4H1A provides that service may be made in a manner prescribed by Rule 4E1 by serving an individual. This appears to authorize service by the means permitted under state law for serving a person, but it can't mean that you can't deliver the papers to a corporation personally, nor can you leave them at a corporation's dwelling house. Rather, this means that to service on individuals, the plaintiff may invoke the service rules for serving a corporation. While this proposition seems utterly self-evident, it's hard to find cases that state it, perhaps because it is self-evident. See Duckworth v. GMAC Insurance from 2010. However, one second, I have to plug myself in. However, also allows for service pursuant to state law. The court therefore must review state law regarding proper service of process on a corporation. Service on other entities. Your firm is bringing a federal civil action against the city of Denver, the Federal Small Business Administration, and Penny Wright, a law firm. You are to determine how to serve the service of complaint by each of these entities. Under Rule 4, how to use the process of these defendants. To answer a question like this, it makes sense to start by looking at the federal rules. Students desperately resist looking at them, but you can gain experience and practice, and you will come to appreciate how many questions they answer by procedure. Rule 4 specifies method of service for each of the defendants. The City of Denver, you should deliver a copy of the summons with money to the city's chief executive officer. Federal Civil Procedures 4J2A. A little research would likely confirm that is the mayor. Or you can use a method authorized by Colorado law for serving process on local government. Federal Rule of Civil Procedure 4J2B. Federal Small Business Association. You would research to confirm this, but it certainly appears that the Small Business Administration is a federal agency. If so, Federal Rules of Civil Procedure P4I2 applies. Under the provision, you must serve the United States. See the provisions for doing so, Federal Rules of Civil Procedure 4I1, and send a summons and complaint by registered or certified mail to the agency. Opinion right, the law firm is likely a partnership or corporation, thus you can use one of the methods provided in Federal Rules of Civil Procedure 4H. That wasn't so bad, actually. Comedy of error, some practice in applying the service rules. Consider whether service of process is proper in each of the following cases. Under Federal Rule 4, disregard the possibility of using state service rules. Hugo, the plaintiff, serves the defendant Hyde, the individual by delivering the summons and complaint to himself. No good. Hugo, as a party, is not authorized to serve process himself. Federal Rules of Civil Procedure 4C2. Hugo serves Hyde by having a private process service deliver the complaint to Hyde at her office. Still no good. Hugo did not have a copy of the summons delivered with the complaint. Federal Civil Procedure 4C1. Hugo sues Jekyll and Hyde to unrelated individuals he served process by having process server deliver 2 copies of the summons and the complaint to Jekyll at his home. Process has been properly served on Jekyll, but not on Hyde. Each defendant must be served separately unless Jekyll is Hyde's agent for service of process. Hugo's, and then do you need to give me 2 or just 1? Figure that. Hugo serves Jekyll. Okay. Hugo serves Jekyll by serving process services with summons and complaint at his house with Jack, a friend of Jekyll who was in town for a convention. This also does not comply with order. Must be left with a person of suitable age and discretion who resides there. A visiting conventioner would probably not qualify. Hugo serves Jekyll by having a process service leave the summons and complaint with Jekyll's wife Jane at the restaurant she runs. No, it has to be where she lives. Thus again, the process server delivered the papers to Jane at Jane and Hugo's home. This will comply with Rule 4E2B. But the rule does not allow service on Jane or some other location. Hugo sues Jane's Restaurant Corporation as a process by having the process service deliver the summons and complaint to Child, a pastry chef at Jane's Restaurant. Another Flapper Corporation must be served by delivering the papers to the managing general agent and then Child. Funny. A managing or general agent of the corporation, but it is doubtful that a pastry chef fits this definition. Hugo sues Jane's Restaurant Corporation, which owns a restaurant in Minnesota, and in a Minnesota federal court, the process server delivers the summons and complaint to Jane, president of Jane's, while she is visiting her mother in Wisconsin. No problem. The corporation may be served by delivering the papers to an officer. Federal Rules of Civil Procedure 4A, 1B. The rule does not require the officer to be in any particular place when she receives service. Hugo sues Jekyll and hires Moth, a lazy process service, to set process on Jekyll. Moth drops the paper down the sewer and files an affidavit with the court attesting that he served the papers on Jekyll personally. This boy is common enough to have his own name, sewer service. What? Clearly, it is inadequate and illegal and cannot support a valid judgment. As a plaintiff's lawyer, you want to develop a relationship with a reliable process service to avoid this risk. Service on parties outside the United States. Litigation, like so much else to states. It's going global. Foreign defendants are frequently sued in the United States courts and must be served with process. Courts and statutes typically provide a number of methods for making international service. Rule 4F provides several methods for process for service process on individual defendants in other countries and federal cases. Service may be made as provided by international agreements such as the Hague Convention of Service Abroad and judicial or extrajudicial documents. Federal Rules of Civil Procedure for F1. Many countries, including the United States, have signed the Hague Convention, which provides a mechanism for sending the documents to a designated central authority in the country where service is to be made, which then completes service on the defendant. Using the methods for service of process in the country where service is made, Federal Rules of Civil Procedure for F2A. This method requires researching the procedure rules of the country, which can be difficult, especially when those rules are in a different language. By personal delivery unless prohibited by law of the country where service is made. Again, it may be difficult to ascertain whether personal service is allowed there by a form of mail with a signed receipt unless prohibited by law in the country where service is made, by seeking instructions from an appropriate authority in the country where service is made through letter of request, by seeking a court order for alternative means of service. Federal district courts are not likely to be receptive to such requests. However, from plaintiffs who have not tried one of the other permissible methods. Similarly, state court procedure rules and statutes specify methods for service on defendants outside the United States. See Alaska Rules of Civil Procedure 4D13, which closely tracks the options for federal 4F. Avoiding technicalities, waiver of service process. Federal Rule 4 offers a simple and inexpensive alternative to formal service of process. Under Federal Rule of Civil Procedure 4D, the plaintiff may ask the defendant to waive formal service. The plaintiff sends the defendant a notice of the action with 2 copies of a waiver form, the complaint, and a prepaid envelope for returning the waiver. Federal Civil Procedure 4D1. Defendants have a duty to avoid the cost of formal service. If they do not return the waiver, they must pay the cost of formal service, including the attorney's fees, or any motion to collect those costs. The rule also offers an enticement to defendants to waive service. It gives them 60 days to answer instead of the usual 21. The waiver procedure under 4D may also be used for foreign defendants. Oh, that's good. They have a duty to avoid the cost of formal service and not return the waiver. If they do not return the waiver, they must pay the cost of formal service. Okay. Duty unfulfilled. Alice, counsel for Chang, in a federal action, sends Fuentes, defendant, 2 copies of a waiver form, a stamped returned envelope, and a complaint in compliance with Rule 4D1. The 30-day period for returning the waiver goes by, and she does not get back the waiver form. Okay, so it's 30-day for returning the waiver form, but 60-day to answer. And she does not get back. What should she do next? A clear implication of Rule 4D is here. If the waiver is not returned, the plaintiff must serve process through formal means and Rule 4D2A, which makes the non-compliant defendant responsible for the cost of service. I don't know, I think this is kind of rude. A trap for the unwary. Under the law of some states, the statute of limitations is satisfied by service of process on the defendant within the statutory period rather than by filing the complaint with the court. Assume that this is true of Chang's case. On January 1st, 5 days before the statute of limitation expires on the plaintiff's tort claim against Fuentes, Alice sends Fuentes a request to waive service together with the summons and complaint and return envelope. Fuentes receives it on January 4th, 2 days before the statute runs, and returns it on January 24th, 4 days later. Alice files it with the court 2 days later on January 26th. When Fuentes answers the complaint, he asserts as the defense that the claim is barred by the passage of the statute of limitations. How should the court rule? The court should accept the defense and dismiss the claim. Rule 4D4 provides that these rules apply as if a summons and complaint had been served at the time of filing the waiver. Under this rule, service was complete on Fuentes of January 26th when the waiver was filed in the court 18 days after the limitations ran. Although Fuentes received the summons and complaint before the limitations ran out, a service is not complete by waiver until it's filed, so he was not served on time. Note, however, that returning the waiver only waives the duty to serve process. Okay. Note, however, that returning the waiver only waives the duty to serve process under Rule 4. It does not waive any other objection the defendant may waive, such as an objection to jurisdiction or venue. The provision that service is effective upon filing the waiver avoids difficult factual issues about when the defendant received the papers, which plaintiff will not know. It clearly suggests, however, that if the limitation period is about to run out, counsel should not use the waiver procedure since Fuentes might not return the waiver form at all or return it too late to meet the limitations period. The provision governing waiver of service were added to Federal Rule 4 in 1983. Although many states' rules of civil procedures are modeled on the federal rules, it appears that many have not amended their rules to allow for waiver of service process. For one that has, see Virginia Code, section 808-01286, adopted in 2005. Possibilities for manipulation. Galega is sued by O'Hara for breach of contract in federal court. O'Hara serves a summons and complaint on Galega, but service does not comply with any of the methods authorized in Rule 4. Galega answers the complaint and begins discovery. 6 months later, after the statute of limitations has passed, Galega moves to dismiss the action, arguing that she was not properly served with process and that the court cannot acquire jurisdiction over the defendant without proper service. Assuming the court agrees the service is improper, what would the court do? You can see how a defendant might engage in serious manipulation if she could keep this objection in her pocket and raise it later to get rid of the case. Here, for example, O'Hara might be unable to refile the action if it was dismissed after 6 months. Here, for example, O'Hara might not be able to refile the action if it was dismissed after 6 months, since the limitations period has passed. To avoid such tactical maneuvering, the Federal Rules of Civil Procedure that provide that objections to service and process must be raised early in litigation, either by pre-answer motion or answer to complaint. Also, she waits 6 months to say that she didn't have proper service after the statute of limitation passed. So you have to bring it up early, or you can't, because then they wouldn't be able to refile because the statute of limitations had passed. Service of process in state courts. The federal rules provisions for service of process do not apply in state courts. Every state provides methods of service of process in its court by statute or court rule. Of course, such provisions like those for service in federal court must comply with the due process standard in Mullane. This section illustrates state methods of service based on a divorce case filed in a New York State court. Service methods for divorce cases in New York law. New York has a special provision for service of process in divorce cases, which provides in part, a judgment shall not be rendered in favor of the plaintiff upon the defendant's default in appearing or pleading unless 1, the summons and a copy of the complaint were personally delivered to the defendant. 2, the copy of the summons, A, personally delivered to the defendant or served on the defendant pursuant to an order directing the method of service of summons in accordance with the provisions of section 308 or 315 of the Civil practice law and rules. A judgment should not be rendered in favor of the plaintiff. A judgment should not be rendered in favor of the plaintiff upon the defendant's default in appearing or pleading unless either one, the summons and a copy of the complaint were personally delivered to the defendant, two, the copy of the summons a person delivered to the defendant, or B, served on the defendant pursuant to an order directing the method of service of summons in accordance with the provisions of section 308 or 315 of the civil practice law and rules shall contain such notice. New York Domestic Relations Law 232A. Notice that this section allows service if personal delivery is not possible through various methods specified in section 308 of the civil practice law and rules referred to in Baidoo opinion as CPLR section 308 provides in part. Personal service upon a natural person shall be made by any of the following methods. One, by delivering the summons within the state to the person to be served, or by delivering the summons within the state to a person of suitable age and discretion at the actual place of business, dwelling place, or usual abode of the person to be served, and by either mailing the summons to the person to be served at his or her last known residence, or by mailing the summons by first class mail to the person to be served at his or her actual place of business in an envelope bearing the legend personal and confidential and not indicating on the outside thereof by return address or otherwise that the communication is from an attorney or concerns an action against the person to be served. Such delivery and mailing to be effected within 20 days of each other, or for service under paragraphs 1 and 2 cannot be made with due diligence by affixing summons to the door of either that or service cannot be made with due by affixing the summons to the door of either the actual place of business, dwelling place, or actual place of abode within the state the person to be served, by either mailing the summons to such a person's last known residence, by mailing by first class by return envelope, or otherwise that the communication is from an attorney or concerns an action against the person to be served, such as affixing and mailing to it's within 20 days of each other. In such manner as the court upon motion without notice directs, if service is impracticable under paragraph 1, 2, and 4 of this section. New York CPLR 315 cited 232A also authorized service by publication if service cannot be made by another prescribed method with due diligence. A hierarchy of service methods. Note, in each manner as the court upon motion without notice directs if service is impractical. Okay. A hierarchy of service methods. Note in section 232A. Note that section 232A establishes a preferred method of service in divorce actions by personal delivery of the summons and complaint to the defendant under section 232A1 or personal delivery of the summons under 232A2A. If service is made by personal delivery, no order from the court is required. If personal delivery is not possible, for example, if the defendant avoids service or her whereabouts are unknown, section 232A authorizes service under one or more of the alternative methods in section 308 as ordered by the court. By delivering the summons to a person of suitable age and discretion at the defendant's place of business or residence and mailing the summons to the defendant's place of business, section 3082, or by affixing the summons to the door of the defendant's place of business, dwelling place, or other place of abode within the defendant's state of domicile, and by mailing the person's last known residence or actual place of business, or in a manner ordered by the court if other methods are impracticable. If an alternative method is used, the court must approve this method again to assure that service is likely to provide actual notice. The court can consider the circumstances and enter an appropriate order for service either through one of the methods specified in section 308 or through another method likely to provide actual notice of the action of the defendant, or through a combination of methods. These provisions differ in some respects from the methods of service specified in Federal Rule 4 and in some respects are more stringent. Remember, however, that Federal Rule 4 authorizes use of methods of service of process permitted by either the state where the action is pending or the state where the service is made. In addition to the service methods specified in Rule 4 of the Federal Civil Procedure 4E1, 4H, 1A. The Baidoo case below applies these New York statutory provisions for service of process in a divorce case. Reading Baidoo versus Blood-Dzraku. This case was filed in state court, so the New York statute governing methods of service reviewed above apply, not the federal rules. Because the defendant could not be served by personal delivery, the court reviews other methods available under New York law. Consider the following questions of reading Baidoo. If the plaintiff cannot serve the defendant in person, what must she do to make proper service? Did the Baidoo court consider the constitutional standards of Mullane, as well as New York service statutes, in deciding whether to authorize service via Facebook? What concerns did the Baidoo court have about authorizing service by social media? Why did the court reject the service through publication, timeline, or last resort for notifying the defendant of an action? Baidoo v. Blood-Dzraku, New York State, 3rd District, 309, Matthew F. Cooper J. As recently as 10 years ago, it was considered a cutting-edge development in civil procedure for a court to allow a service of summons by email. Since then, email has all but replaced ordinary mail as a means of written communication, and while the legislator has yet to make email a statutory authorized method of service and process, courts are now routinely permitting it as a form of alternative service. The past decade has also seen advent of ascendancy of social media, with websites such as Facebook and Twitter occupying a central place in the lives of many people. Federal residual procedures bar service or process by a party, perhaps to avoid physical harm. Oh, the many include 157. The many include the 157 billion people in the United States who, according to Facebook 2014 fourth quarter shareholder report, check their Facebook accounts each day. It does not, by and large, include the members of the New York State Judiciary who have been advised they should be wary of using social network sites. See Advisory Committee on Judicial Ethics Opinion 08176 2009, Advisory Committee on Judicial Ethics Opinion 13-39 2010. Also, Richard Reisman and Peter Brown, Judicial and Attorney Misuse of Social Media Can End Careers. Interesting. This is really interesting. Read this later. Judicial and attorney misuse of social media can end careers. Attorney misuse of social media. What's the guy's name? Richard Reisman. Let me just make a note here to look for this document. All right. Great. I'm going to make a note. It's very interesting. All right. Thus, it would appear that the next frontier in developing law of the service of process over the internet is to use social media sites such as forums through which summons can be delivered. In the matrimonial action, the issue before the court by way of plaintiff's wife's ex parte application is whether she may serve defendant husband with divorce summons solely by sending it through Facebook by private message to his account. The standard method, or perhaps better stated, the method of first resort for serving summons in a divorce action is personal delivery to the defendant. Domestic Relations Law, Section 232A. This reflects the great emphasis that the state places on ensuring that a person who is being sued for divorce, a proceeding that can have immeasurable financial and familial consequences, be made aware of and offered the opportunity to appear in the action. The problem with personal service, of course, is that in order for it to be accomplished, a plaintiff must be able to locate the defendant. Even where a defendant's whereabouts are known, there are times when it is logistically difficult, if not impossible, for a process service to gain the close proximity necessary for personal delivery. Fortunately, the domestic relations law provides a remedy for a person who is seeking divorce but faces the prospect of being unable to effect personal service. Domestic relations law, Section 232, permits plaintiffs to request permission to utilize one of the alternative methods allowed under the civil practice law and rules that does not require in-hand delivery to the defendant. One such method, often referred to as substitute service, involves delivering a summons to substitute service involves delivering a summons to a person of suitable age and discretion at the defendant's actual place of business, dwelling, or usual place of abode. Another method, known as mail and mail service, requires affixing the summons to the defendant's actual place of business, dwelling, or abode. And then, as a substitute service, mailing a copy of the defendant's last known resident or actual place of business. A third method is publication service, where the summons is printed in a newspaper designated by the court, at which can be granted upon showing that service cannot be made by another prescribed method of due diligence. Additionally, pursuant to CPLR 308, a court, upon a plaintiff's ex parte application, may direct the manner by which service is made. This allows the court to go beyond any of the specifically prescribed methods of service and devise a method that fits the particular circumstances of the case. An application for alternative service under CPLR 3085 can be granted only upon a sufficient showing that personal service, substitute service, or mail and mail service will prove impracticable. Case law, in accordance with well-established constitutional principles, further imposes requirement that the method devised by the court be one that is reasonably calculated under the circumstances to appraise the defendant of the pendency of the action. Hollow v. Hollow, 2002, quoting Mullane v. Central Hanover Bank and Trust Company. In the instant application, plaintiff asked the court to find that service of the divorce summons via social media site, in this case Facebook, constitutes an appropriate form of alternative service under CPL 3058. Moreover, contending that she has no other way to reach the defendant, she requests that this judicially crafted method of service be designated the only means by which notice of the divorce action is given. In order for her application to be granted, plaintiff must first demonstrate that she is unable to have the summons personally served on the defendant, the method of service initially prescribed by the Domestic Relations Court in Section 232A. Next, she must show that it would be impractical to serve him by substitute service or on a person of suitable age and discretion by using suitable age and discretion or nail and nail. Finally, she must show that sending the summons through Facebook can reasonably be expected to give him actual notice that he is being sued for divorce. Plaintiff has easily met the requirement of demonstrating that she will be unable to effect personal service on the defendant. Although the parties married in 2009, they never resided together, and the last address plaintiff had for the defendant was an apartment that he vacated in 2011. Plaintiff has spoken to the defendant by telephone on occasion, and he has told her that he has no fixed address and no place of employment. He has also refused to make himself available to be served with divorce papers. As detailed in her attorney affirmation, the investigative firms that plaintiff hired to assist in locating the defendant have all been unsuccessful in their efforts. The post office has no forwarding address for him. There's no billing address linked to his prepaid cell phone, and the Department of Motor Vehicles has no record of him. And as much as plaintiff is unable to find defendant, personal delivery of the summons to him is an impossibility. Similarly, plaintiff has shown that it would be an exercise in futility to attempt the two alternative service methods provided in CPLR 308. Both substitute service and mail and mail service require knowledge of the defendant's actual place of business, dwelling place, or usual abode. The record establishes that plaintiff has been unsuccessful in obtaining either a business or home address for defendant, even though she has diligently sought the information. As a result, she has met her burden of demonstrating that it would be impracticable to attempt to serve defendant by either of these methods. Having demonstrated a sound basis for seeking alternative service pursuant to CPLR 3085, plaintiff must show that the method she proposes is one that the court can endorse as being reasonably calculated to appraise the defendant that he's being sued for divorce. This hurdle poses a number of challenges. First, there are only a handful of reported decisions, mostly in federal district courts, that have addressed the issue of service process being accomplished through social media, with there being an almost even split between the decisions approving it and those rejecting it. Second, as it will be further discussed, the cases permitting such service have done so only on condition that the papers commencing the lawsuit be served on the defendant by another method as well, thus seeking permission to effectuate service of the divorce summons by simply sending it to the defendant through private Facebook message. Plaintiff is asking the court already beyond the safe harbor statutory prescription to venue into uncharted waters without guiding light of clear judicial precedent. Considerations must be given to the fact that the way plaintiff proposes to provide the defendant with notice of divorce represents a radical departure from the traditional notion of what constitutes service of process. Even decisions from as recently as 2012 and 2013 have referred to the use of Facebook messaging for the purpose of commencing a lawsuit as being a novel concept, permitting it as a supplemental method of service and unorthodox, to say the least. This concept is new to the law and is something that may well require a court to exercise a high degree of scrutiny and independent legal analysis wherein judicial approval is sought. But a concept should not be rejected simply because it is novel and non-traditional. This is especially so when technology and law intersect. In this age of technological enlightenment, what is for the moment unorthodox and unusual stands a good chance of sooner being later accepted as standard and even outdated and passé. And because legislators have often been slow to react to these changes, it is often fallen to the courts to ensure that our legal procedures keep pace with current technology. As noted in the United States Courts of Appeal, Ninth Circuit, Rio Props Inc. versus Real International Interlink, one of the earliest cases authorizing service of process by email. Broad constitutional principle upon which judicially devised alternative service is based unshackles courts from anachronistic methods of service and permits them entry into technological renaissance. In the final analysis, constitutional principle is not the lack of judicial precedent or the novelty of Facebook service will be ultimately determinative here. The central question is whether the method by which the plaintiff seeks to serve the defendant comports with the fundamentals of due process by being reasonably calculated to provide the defendant with notice of the divorce, or more simply posed, if the summons of divorce is sent to what plaintiff represents to be defendant's Facebook account, is there a good chance he'll receive it? In order for the question to be answered, an affirmative plaintiff must address a number of the court's concerns. The first is that the Facebook account the plaintiff believes is defendant might not actually belong to him. As it is well known, the Facebook profile somebody views online may well belong to someone other than whom the profile purports it to be. This has led courts to observe that anyone can make a Facebook profile using real, fake, or incomplete information, and thus there is no way for the court to confirm whether the Facebook page belongs to the defendant to be served. As a result, the court requires plaintiffs to submit a supplemental affidavit to verify that the Facebook account she references is indeed that of the defendant. Plaintiff submitted such an affidavit to which she annexed copies of the exchanges that took place between her and the defendant when she contacted him through his Facebook page, and in which she identified defendant as the subject of the photographs that appear on the page. While it is true that plaintiff's statements are not absolute proof that the account belongs to the defendant, it being conceivable that if plaintiff herself or someone has created a defendant page, she could fabricate exchanges and post photographs. Plaintiff has nevertheless persuaded the court that the account in question does indeed belong to the defendant. The second concern is if the defendant is not diligent in logging into his Facebook account, he runs the risk of not seeing the summons and that the time to respond has passed. Here, too, plaintiff's affidavit will successfully address the issue. Her exchanges with the defendant on Facebook show that he regularly logs onto his account In addition, because plaintiff has a mobile phone number for the defendant, both she and her attorney can speak to him or leave a voicemail or send him a text message alerting him to the divorce action has been commenced and that he should check his account. Who's here? Okay. Courts have taken into consideration whether the defendant already possessed either knowledge of the suit or that he may be the subject to a suit. The third concern is whether a backup means of service is required under the circumstances. Although, as we've discussed, other courts' decisions have endorsed using Facebook as a means of service, they have done so only as where Facebook was one of the methods employed, not the only method, as the court stated in PCC Care 2470. To be sure, the plaintiff was proposing to serve defendants only by means of Facebook as opposed to using Facebook as a supplemental means of service. A substantial question would arise whether that service comports with due process. In that case, as well as in Who's Here Inc., the other federal court decision authorizing Facebook service, the court stressed that it was not allowing the use of social media site only in conjunction with notice being sent to defendants. It was allowing the use of service only in conjunction with notice being sent to defendants by email. The only decision from a state court permitting service via Facebook, the petitioner was required to mail a copy of the child support summons and petition to the respondent's previously used last known address. Here, plaintiff does not have an email address for the defendant and has no way of finding one, nor does she have a street address for defendant that could constitute a viable last known address. Defendant's last known address dates back at least 4 years, and the post office confirmed the defendant no longer resides there and has left no forwarding address. Thus, the plaintiff has a compelling reason to make Facebook the sole rather than supplemental means of service, with the court satisfied that it has a method reasonably calculated to give the defendant notice that he's being sued for divorce. Before granting plaintiff leave to serve the defendant via Facebook, a method of alternative service traditionally devised pursuant to CPLR 3085, there is one remaining question that should be addressed. Why use Facebook as either sole or the supplemental means of service in the first place, where there is statutorily described method of service readily available? The method is service by publication, something that's specifically authorized by CPLR 315. After all, publication is not only expressly sanctioned by CPLR, but as a means of service has already been used in New York in one form or another since colonial times. Even today, it is probably the method of service most often permitted in divorce actions when the defendant cannot be served by other means. The problem, however, with publication service is that it's almost guaranteed not to provide the defendant with notice of the action of divorce or any other lawsuit for that matter. In divorce cases brought in New York County, plaintiffs are often granted permission to publish summons in such newspapers as the New York Law Journal and the Irish Echo. If that were to be done here, the chances of a defendant who is neither a lawyer nor Irish of either seeing the summons in print either of those particular newspapers or any other are slim to none. The dangers of allowing somebody to be divorced and not know it is simply too great to allow notice to be given by publication of form of service that, while neither novel nor orthodox, is essentially statutorily authorized non-service. This is especially so when, as here, there is a readily available means of service that stands a very good chance of letting the defendant know that he's being sued. Moreover, the court will not require publication in any newspaper, even as a backup method to Facebook. Although a more widely circulated newspaper like the New York Post or Daily News might reach more readers, the cost of which approximates $1,000 for running a notice for a week is substantial, and the chances of being seen by the defendant bearing some excuse searching the newspaper and printing a small type are still infinitesimal. Under the circumstances presented here, service by Facebook, albeit novel and not traditional, is a form of service that most comports with the constitutional standards of due process. Not only is it reasonably calculated to provide the defendant with notice that he is being sued for divorce, but every indication is that it will achieve what should be the goal of every method of service, actually delivering the summons to him. In light of the foregoing, plaintiff is granted permission to serve the defendant with a divorce summons using private messages Facebook, specifically because litigants are prohibited from serving other litigants. Plaintiff's attorney shall log into plaintiff's Facebook account and message the defendant by first identifying himself and either including a web address of the summons or attaching the image of the summons. This transmittal shall be repeated by plaintiff's attorney defendant once a week for 3 consecutive weeks or until acknowledged by the defendant. Additionally, after the initial transmittal, plaintiff and her attorney are to call and text message the defendant to inform her that the summons for divorce has been sent to him via Facebook. Notice and question state service. And I on the Mullane basics in Baidoo, the court of service analyzes the methods for service authorized under Section 308 of Civil Procedure Laws and Rules, the New York Service of Process Statute, but the court also considers whether alternative forms of service in order to satisfy core constitutional standards of Mullane. The central question is whether the method by which the plaintiff seeks to serve the defendant comports with the fundamentals of due process by reasonably calculated to provide the defendant with notice of divorce. Or more simply posted, if the summons of divorce is sent to the plaintiff represents the defendant's Facebook account, is there a good chance he'll receive it? New York State 3D at 714 technology may change, but the court rightly keeps the focus on the underlying value, emphasizing the likelihood of providing actual notice to the defendant. Considering the alternative, New York CPLR Section 3.8 authorized various forms of alternatives to the preferred methods of personal delivery. The Baidoo court reviews each option and concludes that none of them are reasonably likely to provide actual notice while notification on Facebook properly will reach the defendant. Judges crafting such orders of service under Section 385 are likely to order service in several ways, perhaps mail service at a place of business, publication as well. In Baidoo, Judge Cooper also orders service through multiple methods: Facebook, posting messages to Facebook, and calls and texts to the defendant's cell phone. Facebook posting. As Baidoo knows, some cases have refused to allow service through Facebook, such as the court in Johan Promotion Inc. v. Shepherd rejected Facebook service on the grounds that relevant state law mandated publication notice where the defendant cannot be found. Fortuna v. Chase Bank rejected it on the grounds that the account may have been posted by someone other than the defendant. Generally, the cases turn on whether the facts adduced by the plaintiff convince the court that suggested service methods are actually to reach the defendant. Alternatives to alternative service. In light of Baidoo case, consider whether the motion should be granted in the following case. Harris sues Blood-Dzraku for breach of contract in a New York court. The provisions for New York CPLR Section 3.8 apply to service of process in the action. Harris does not have a current home address for Baidoo. She knows he has moved, but not where he now resides. She has been told that Baidoo travels a lot for work, that has an office at a store on the corner of 5th Avenue and 34th Street in New York City. She isn't sure that is true or which store it is. During negotiations for a contract, Harris communicated regularly with Baidoo through Facebook. She moves for an order for the court, allowing her to serve Baidoo via Facebook calling, citing Baidoo as an authority for using procedure by service. The court will likely grant the motion if Harris meets after testing the facts of the above. Grant the motion only if Harris has made reasonable efforts to locate the store where failed to do so. Grant the motion if Harris can convince the court to use his Facebook account. Deny the motion because Harris is not sufficiently explored the methods of deny. D. For sure, choose D. Section 308 authorizes service as the court directs if service is impracticable under the methods in Section 3.8, 308, 1, 2, and 4. It does not allow the court to go straight to alternative methods of service, whatever the plaintiff argues that is likely to provide action notice to the defendant. On the facts, the court would surely require Harris to make further inquiries to find a home address or business address or both for Baidoo. If post office regulations require forwarding the mail after a patron moves, Harris may be able to serve the papers for Baidoo by mail. She may be able to find his current address for him with a bit of research or by hiring an investigator. An investigator may well locate Baidoo's place of work with the information Harris had. And there's always the manifold resources of the internet. The court will almost certainly require greater efforts to provide Harris to comply with the methods specified in Section 3.8, 1, 2, or 4 to serve Baidoo before authorizing Facebook service. Harris motions to serve via Facebook looks like an effort to avoid more extensive efforts to locate Baidoo rather than the only viable option for serving an elusive defendant. Motion denied. But do the New York service provision authorize service of process through social media? Generally, service of process must both comport with the constitutional standard of Mullane and be authorized by the statute applicable in the relevant court. The New York service statutes do not expressly authorize service to social media. In ordering service through Facebook, the judge in ordering service through Facebook, isn't the judge ignoring the limits on service methods under New York law? Although service through social media is not a specified method of service under Section 308, the New York Civil Procedure Law and Rules CPLR 308 authorizes the court to order alternative methods of service where the specifically authorized methods are reasonably calculated to provide actual notice or have failed to reach the defendant. This fallback provision allows the court to craft different methods of service or multiple methods in an effort to provide actual notice to defendants. Service by publication is the last resort if the defendant cannot be located so that none of the methods of service specified in the relevant court service of process rules is likely to provide actual notice. The plaintiff will typically apply to the court for an order of service through alternative means. In New York, such a frustrated plaintiff would, as Baidoo, plaintiff did seek an order under 3085 of civil practice law and procedure rules. See New York Civil Procedure Law and Rules 3, Section 315, which authorizes service by publication. If service cannot be made by another prescribed method with due diligence, in many cases, courts will order service of process by publication in a newspaper if no alternative exists, or all have been tried without success. Publication would seldom suffice under Mullane as the first and only means of service, but where nothing else has worked. Such substitute service is probably constitutionally sufficient. However, counsel would be well advised to exhaust all of the practical means of notice before seeking notice by publication. In Gates v. Deacon, 2009, plaintiff's counsel made Herculean efforts to find the defendant. He conducted computer searches, mailed papers to address of the defendant, and attempted service by share. Finally, he obtained order of service by publication. The Maine Supreme Court still granted relief from judgment on the grounds that publication was not sufficient in light of other options. Plaintiff counsel might have explored to give actual notice to the defendant. The court suggested, for example, that counsel might have hired an internet web searching service, published notice in an area where the defendant has resided, or used college records to locate members of the defendant's family. The Baidoo case rejected service by publication on practical grounds. Judge Cooper somewhat iconically characterized this centuries-old practice of essentially statutory authorized non-service. Because publication in local or specialized newspapers would be unlikely to provide actual notice, the publication of more widely circulated papers would be too expensive, given the small likelihood that it would actually reach the defendant. Reasonable notice. This snippet here from a local newspaper includes publication notice of a lawsuit. In Mullane, Justice Jackson suggests notice of this sort tucked in the back pages that will seldom satisfy the constitutional side of the average notice. Change alone brings to the attention of even a local resident an advertisement in small type inserted in the chance alone brings the attention of even a local resident advertising this small type inserted in the back pages of the newspaper. And if he makes his home outside the area, the newspaper will never circulate, the odds of that information will never reach him are large indeed. Alternative means of service in federal court. Federal Rule 4 does not contain a provision like Section 308 authorizing federal district court to order service by publication or alternative methods. However, Rule 4 also authorizes service through methods available in the state where the court of the service is made. Thus, the Baidoo case have been a federal. Thus, if the Baidoo case have been a federal court, the federal judge could similarly have crafted an order for alternative service by means of the New York Civil Procedure and legal rules. Describing state methods for service available in federal action under the Minnesota and Iowa Rules of Civil Procedure. The effect of actual notice. Okay, we are going to stop here. I wanted to make it all the way to section 5, but we just don't have the time. So tune in for the next episode of Legally Margaret or Legally Raven here. Thank you.